Picture this as a hypothetical scenario for commentary purposes, because I'm not here to tell you this definitely happened and then leave you with rumors. I'm here to give you a clean, understandable version of what this kind of ruling would mean, what it would not mean, and what the next move would look like if it did happen. In this scenario, the Supreme Court doesn't slowly trim around the edges of gun law. It doesn't issue a narrow decision. It doesn't send the issue back down to lower courts with vague language. It drops a ruling in one morning that lights the entire permit-based system on fire. Not some permits, not permits in certain states. Every system that requires you to ask the government for permission before you can buy, own, or carry a firearm gets declared unconstitutional in one sweep. Every purchase permit, every carry permit, every ownership license, every permission slip that gets sold to the public as a safety measure.
The whole concept is rejected. And the scary part, in this scenario, isn't just the ruling. The scary part is what happens after the ruling. Because the moment a decision like that lands, state governments don't just throw their hands up and accept it. They start working on a workaround. They start asking how they can do the same thing with a different label. They start writing new bills with new names that achieve the same practical outcome, slowing down ownership, filtering out ordinary people, and keeping control inside a bureaucracy. That's why a decision like this would instantly become the biggest gun rights ruling since 2008, and it would also become one of the most misunderstood rulings in modern American law. Because the people who talk about it loudly are usually doing one of two things: cheering as if it's a perfect libertarian dream, or mourning as if it's the end of civilization. Both sides are often so focused on emotion that they skip the job that actually matters, explaining the decision accurately. So let's do that job. Let's talk about what the court actually says in this scenario, what the key line is, and why that one line changes the ground under every state gun law built on permits. In this hypothetical, the case is called National Association for Gun Rights, FIRSI, United States. The holding is simple in wording and massive in consequence. The court says the Second Amendment protects a pre-existing individual right. That phrase matters. A pre-existing right is not something the government hands you. It's not a privilege granted by a clerk, a sheriff, or a licensing board. It's a right that exists before government, meaning government's job is to recognize it and protect it, not sell it back to you under conditions. Then the court draws the line that destroys the modern permit framework. It says government cannot condition the exercise of a constitutional right on obtaining bureaucratic permission. That's the wall. That's the boundary. That's the sentence that, if you take it seriously, makes most permit schemes legally impossible to defend. Now here's the part that a lot of people refuse to accept because it breaks the logic of their entire regulatory system. The court's reasoning hinges on a distinction that sounds small but is actually everything: verification versus permission. Verification means the government checks whether you are legally eligible to exercise a right you already have. Permission means you must ask the government whether you get to have that right at all, and the government can say yes or no based on process, delay, fees, discretion, or good cause. Those are not the same thing. They never were. But for decades, states blended them together and hoped courts would let them. In this scenario, the Supreme Court stops the blending. It says verification can be constitutional, permission is not. That means background checks can survive, because a background check, when done as a true eligibility check, is verification. You buy from a licensed dealer, your eligibility is confirmed through an existing system, and then you complete the purchase. But permit systems, in their traditional form, are permission systems. You fill out paperwork, you pay fees, you take mandated classes as a condition, you wait, you appear for appointments, you get your fingerprints. You ask a local official for approval, and sometimes that official has broad discretion to delay you, deny you, or force you through hoops that have nothing to do with whether you're prohibited. That is not a neutral verification step. It's a gatekeeping system. It's a way of turning a right into a managed privilege. Under the logic of this hypothetical ruling, anything that functions as "you can't do this until the government gives you a license" becomes unconstitutional, even if the state calls it a safety measure, even if the state insists it's reasonable, and even if the state argues that it saves lives. The constitutional problem isn't whether the state has good intentions. The constitutional problem is the mechanism, conditioning the right on permission. Now let's make this real, because otherwise people treat it like law school theory. Under a ruling like this, a lot of normal systems in heavily restricted states would collapse overnight. In places where you needed an identification card just to possess a firearm in your own home, that requirement would be dead. The concept that you must apply and wait and get a card issued by local authorities simply to keep a firearm on private property would be treated as a permission layer, not a verification layer. If local law enforcement had discretion to decide who is suitable, that would be even harder to defend. In places where you needed a separate license to carry, on top of a separate license to possess, both layers would be treated as unconstitutional if they function as permission slips. If the state system is, we can deny ordinary people unless they convince us they have a special reason, that kind of discretion would be directly targeted as a violation of the right. In places where a card was required that effectively operated as a statewide gatekeeping program, often with renewals, fees, delays, and a system that can be used as a proxy registry, that framework would be gone if it is a condition of simple ownership. In places with waiting periods that are not tied to the time needed to run an actual eligibility check, those waiting periods would be in serious trouble under the logic of, you can't delay a right as a disguised permission requirement. If the background check is instant or near instant and the state still forces a multi-day delay as a cooling-off rule, the question becomes, is that really verification, or is it permission by delay? In this hypothetical, the court treats it as the latter. At this point, people usually start yelling in extremes, so let's get specific about what this does not mean, because that matters just as much. It would not mean you can do anything you want with a firearm. It would not mean no laws. It would not mean the Wild West. And it would not mean the government loses the power to keep guns out of the hands of legally prohibited people. If you hear someone claiming the ruling ended background checks or made it legal for felons to buy guns, that is either misunderstanding or deliberate propaganda. What remains intact under this hypothetical framework is the core prohibited person structure that already exists in federal law and in most state laws. If you are a convicted felon, you remain prohibited. If you have a qualifying domestic violence conviction, you remain prohibited. If you are under an active restraining order that triggers federal restrictions, you remain prohibited. If you've had a disqualifying mental health adjudication by a court, you remain prohibited. If you are otherwise disqualified under existing law, you remain prohibited. Nothing about eliminating permits magically deletes those categories. Background checks also remain. The National Instant Check System still runs at the point of sale through licensed dealers. It still blocks prohibited persons. The court's issue in this scenario is not with checking eligibility. The court's issue is with forcing ordinary, law-abiding citizens to go through licensing, delay, fees, and discretionary approval as a condition of exercising the right. And what about where you can carry? That does not become anywhere, anytime. Sensitive place restrictions generally remain lawful. Federal buildings remain restricted. Courts remain restricted. Airports remain restricted. Schools remain restricted under existing federal law. And a ruling focused on permits does not automatically erase location-based restrictions. What changes is the general rule for public carry where carry is otherwise lawful. Under this hypothetical, the law-abiding person who passes an eligibility check does not need to ask the state for a permit to carry in ordinary public spaces. You still have to respect restricted locations. You just don't have to buy a government permission slip for the general act of carry. That distinction is not a small one. It means the state cannot turn the right into a privilege that is handed out only after delays, fees, and bureaucratic hurdles. But it also means you still need to know the actual rules of lawful carry in your jurisdiction, including prohibited locations and prohibited conduct. Now let's address something that gets lost in political shouting: training. If the government can't force training as a condition of your rights, that does not mean training is pointless. It means training becomes your responsibility instead of a government gate. In a system like this, training isn't something you do to earn your rights. Training is something you do because you're an adult and you're taking responsibility for a serious tool. If you're going to own or carry, you should know safe handling. You should know safe storage. You should know how to avoid negligent discharges. You should know the legal boundaries of self-defense in your state. You should know how to interact with law enforcement if you're carrying. You should know how to avoid escalating situations that don't need force. This is what freedom actually demands, not just fewer restrictions, but more personal responsibility. A system that used mandatory training as a gatekeeping mechanism often did two things at once. It made the process harder for ordinary people, and it gave politicians a talking point that sounded like safety while functioning like control. In this hypothetical, the training requirement as a condition dies, but the need for competence doesn't die. If anything, it becomes more important because you can't outsource your responsibility to a certificate. Now we need to talk about what comes next, because this is where the real fight would move immediately. A ruling like this wouldn't end gun control efforts. It would force them to change form. When courts shut down a mechanism, government doesn't usually abandon the goal. It looks for a new mechanism that survives legal review. The language changes, the structure changes. The practical outcome is often designed to stay the same. If permit requirements are struck down as unconstitutional, the first wave of compliance laws would likely be compliance in name only. States would start building systems that avoid the word permit while recreating the permit in function. One predictable move would be registration systems framed as not permission. The state would argue, "We're not granting permission to own a firearm. We're simply requiring you to register the firearm you already own." That sounds different to people who don't track legal mechanics, but it can serve the same control function because a registry creates surveillance and enforcement leverage. Once the state knows who has what, the state can pressure compliance with future rules, target enforcement, and raise the cost of ownership over time. Another move would be eligibility certificates that are marketed as verification rather than licensing. You wouldn't need a permit, they'd say. You just need a certificate that proves you're eligible. But that certificate would require an application, fees, an appointment, processing time, renewals, and possibly broad agency discretion. In other words, it walks and talks like a permit, but it has a different name. If the court's line is truly no conditioning rights on bureaucratic permission, then these certificates would likely face immediate legal challenges because function matters more than the label. Another move would be safe storage mandates tied to inspection authority. Again, marketed as safety, but designed as leverage. If the state says, "You're free to own a firearm, but we can enter and inspect your home to verify compliance," that becomes a major expansion of state power. Even if inspection is limited, it creates a new control point that can chill ownership. Some people will comply, some will refuse, some will get targeted, some will get charged. The enforcement angle becomes the real issue. And you would almost certainly see aggressive use of fees, taxes, and administrative requirements designed to raise the cost of exercising the right. In other areas of constitutional law, courts have been skeptical of poll tax-style mechanisms. If a state tries to impose huge fees that functionally price people out, that can become another constitutional battle. But governments will try, because money and bureaucracy are tools of control that don't require an officer at your door. They just require you to give up out of exhaustion. This is also the part where well-funded national organizations would pour money into model legislation, legal defense strategies, and PR campaigns. Groups that support tighter gun laws would coordinate with state officials to design frameworks that can survive the new legal test. They would fund sympathetic lawsuits. They would test language in friendly jurisdictions. They would encourage states to pass laws quickly and dare opponents to sue. On the other side, gun rights organizations would be forced to file immediate challenges all over the country, because once states start implementing workarounds, those workarounds have to be stopped early or they become the new normal. So to understand why this hypothetical ruling would be so massive, it helps to understand the real arc that led to the modern Second Amendment legal framework. In 2008, District of Columbia versus Heller recognized that the Second Amendment protects an individual right to keep and bear arms for lawful purposes, especially self-defense. And that the right is not limited to militia service. That was a major shift because for years, many lower courts had treated the Second Amendment as a collective right tied to organized militia contexts. In 2010, McDonald v. Chicago applied that individual right against the states through the 14th Amendment, meaning states and local governments could not treat the Second Amendment as something that didn't apply to them. But for years after that, the big unresolved issue was the standard of review. Lower courts often used balancing tests that weighed public safety interests against the right, and those courts frequently upheld restrictions using broad arguments about government interest. That allowed many permit schemes and heavy regulations to survive, even though they functioned as permission systems. In 2022, New York State Rifle and Pistol Association versus Bruin changed the test. It rejected interest balancing and emphasized that gun regulations must be consistent with the nation's historical tradition of firearm regulation. In plain terms, the government can't just say, we think this is good policy. It has to show that a comparable kind of restriction fits within the historical boundaries of how the right was understood at the relevant periods of American constitutional history. If you apply that kind of historical analysis seriously, modern licensing and permit systems become difficult to justify as a founding-era tradition. That's why, in this hypothetical scenario, the May 2026 ruling would feel like the next step. It takes the logic of, you can't treat the right as second class, and applies it directly to the central mechanism that many states use to control ownership and carry, permission through permits. Now, where would that leave ordinary people in the first month after a ruling like this? In reality, it would be messy, because court rulings and state compliance don't always move at the same speed. Some states would comply quickly, some would stall, some would pass emergency replacements. Some local agencies might keep enforcing old rules until they are formally stopped. That gap is where chaos happens, and chaos is where people accidentally get themselves into legal trouble. So, speaking generally and responsibly, if someone is navigating a post-ruling environment like this, the first thing is to know your own legal status. If you are prohibited under existing law, this kind of ruling would not be a magic reset. If you have disqualifying convictions or orders, you are still prohibited, and trying to test it is a fast path to serious charges. If you are not prohibited and you are buying through lawful channels, documentation matters. Keep receipts. Keep purchase records. Keep whatever proof shows you acquired the firearm legally. Not because you want paperwork for its own sake, but because transitional periods create enforcement confusion, and proof protects you if a local official decides to act like nothing changed. If you choose to carry, you still need to respect sensitive place restrictions and location rules. Don't carry into restricted federal locations. Don't carry into courts. Don't carry into schools where prohibited. The political reality is that opponents of gun rights will seize on any high-profile violations as proof that the ruling caused disorder, and they will use that narrative to push new restrictions. Even aside from politics, violations can carry serious legal penalties, and a ruling about permits doesn't erase every other firearm law. Now zoom out from the individual level to the legal and political level, because that's where the next battle would be decided. If states respond with workaround laws, registries, certificates, punitive fees, inspection-driven storage rules, those laws would have to be challenged fast and consistently. Courts move slowly, but the window right after a major Supreme Court ruling is when legal standards get established in lower courts. Early cases shape how everyone interprets the new rule. That is why organizations that litigate gun rights cases would become central players, just as organizations that litigate for gun control policies would become central players. This wouldn't be about internet debates. It would be about lawsuits, injunctions, appeals, and the slow grind of federal court. It's also worth acknowledging something people like to pretend isn't relevant. Supreme Court composition matters. Decisions like this don't happen in a vacuum. They happen because the court has the votes. And votes on the court exist because presidents nominate and the Senate confirms. That's not a partisan talking point. It's just how the system works. If future appointments shift the court, the boundaries of the right can shift again through later cases that narrow, distinguish, or partially reverse what was decided. That's why anyone who thinks one decision settles it forever is misunderstanding American law. Rights are protected by decisions, but they're also protected by continued political engagement, continued litigation, and continued public attention. Now let's get to the core principle underneath this whole scenario, because this is bigger than gun policy, and it touches every constitutional right. The question a ruling like this answers is not simply, how do we regulate firearms? The deeper question is, are constitutional rights actual rights, or are they privileges administered by the state? A right that you can only exercise after the government issues you a permit is not a right in the full constitutional sense. It's a privilege with paperwork. It's something the state can slow walk, deny, price out, or turn into a system of selective access. And if you normalize that structure for one right, you lay down the legal logic that can spread to others. People often see this immediately when it's applied to speech. Imagine if you needed a permit to post political opinions online. Imagine if you needed a license to attend a protest. Imagine if you needed a government-issued eligibility card to publish a newspaper. Most Americans instinctively understand that those would be unconstitutional because they put permission in front of the right. But for decades, many states built a framework around the Second Amendment that treated it differently. They treated it as if it could be conditioned on government approval, even when other rights could not. The argument was always dressed in the language of safety, but the mechanism was still the same. Permission first, right second. In this hypothetical, the Supreme Court rejects that architecture. Not because firearms are harmless, not because public safety doesn't matter, but because the Constitution doesn't allow a system where a fundamental right only exists after a bureaucrat signs off. The government can verify eligibility. The government can punish misuse. The government can restrict certain sensitive locations. But the government can't make you ask permission to exercise a right you already possess. And that's why the next phase after a ruling like this would be so ugly. Because the permit framework isn't just a policy preference. For many states and many institutions, it's a power structure. It's how control is maintained. It's how delays are created. It's how denials are justified. It's how databases get built. It's how compliance becomes exhausting. When a court removes that tool, the institutions that relied on it don't simply shrug and accept less control. They search for the next tool. So if a ruling like this landed, you would likely see a wave of laws that look different on paper but function similarly in practice. You'd see politicians insisting, this isn't a permit, it's a safety certificate. You'd see talking points about responsible gun ownership used to sell systems that recreate permission through delay. You'd see lower courts wrestling with how to apply the new standard, and you'd see some judges trying to carve out exceptions large enough to preserve the old system under a new name. You'd also see potential enforcement conflicts in states that resist compliance. Some people could get arrested under laws that are no longer valid under the new ruling, at least until courts issue clear injunctions and agencies change their procedures. That's part of why transitional periods are dangerous. The law on paper changes instantly, but the system on the ground often changes slowly. All of that is why staying informed is not a slogan. It's strategy. The next restriction in a state capital is often written to count on public ignorance. It's written to sound harmless. It's written to seem like a technical adjustment. It's written so that by the time ordinary people understand what it actually does, it's already law and already enforced. So if you're following an issue like this, the smart move is to track proposed bills, not just final laws. Track agency memos, track attorney general guidance, track injunctions, track what your state is doing to comply, and most importantly, track whether the new system is truly verification or whether it is permission wearing a disguise. Because that's the battlefield line in this hypothetical. Verification, checking if you're prohibited. Permission, making you beg a bureaucracy to exercise a right.